The state bar is an unconstitutional monopoly and an illegal and criminal enterprise that violates Article 2, Section 1, Separation of Powers Clause of the Constitution. There is no power or authority for joining of legislative, judicial, or executive branches within a state as the bar is attempting. Bar members have invaded all branches of government and are attempting to control the de jure governments as agents of a foreign entity. It is quite simple to see that a great fraud and conspiracy has been perpetrated on the people of America. The American Bar, British Accreditation Registry, is an offshoot from the London Lawyers Guild and was established by people with invasive monopolistic goals in mind. In 1909 they incorporated this traitorous group in the state of Illinois and had the state legislature, which was under the control of lawyers, pass an unconstitutional law that only members of this powerful union of lawyers called the American Bar Association could practice law and hold all the key positions in law enforcement and the making of laws. At that time, Illinois became an outlaw state, and for all practical purposes they seceded from the United States of America. The Bar Association then sent organizers to all the other states and explained to the lawyers there how much more profitable and secure it would be for them, as lawyers, to join this union and be protected by its bylaws and canons. They issued to the lawyers in each state a charter from the Illinois organization. California joined in 1927, and a few reluctant states and their lawyers waited until the 1930s to join, when the Treasonous Act became de facto and the citizens became captives. Under this system, the lawyers could guarantee prejudged decisions for the privileged class against the lower class. This was all made possible by the American Bar Association to favor codes and unlawfully substitute them in place of constitutional laws. The Constitution was written in plain English, and the statutes passed by Congress were also in plain English, with the intent of Congress how each law should be used, and not the opinions of various judges as the codes list. Any normal person can read the Constitution and statutes and understand them without any trouble. The public in California was shocked to learn that the state government has no control or jurisdiction over the Bar Association or its members. The state does not accredit the law schools or hold bar examinations. They do not issue state licenses to lawyers. The Bar Association accredits all the law schools, holds their private examinations, and selects the students they will accept in their organization and issues them so-called licenses, but keeps the fees for themselves. The bar is the only one that can punish or disbar a lawyer. They also select the lawyers that they consider qualified for judgeships and various other offices in the state. Only the Bar Association or their designated committees can remove any of these lawyers from public office. The state legislature will not change this system, as they are also a designated committee of the bar. On August 21, 1984, Rosebird, Chief Justice of the California State Supreme Court, another of the Bar Association's judicial committees, stated in essence that the bar should determine the legality of all initiatives before they were allowed to go on the ballot. This is contrary to both state and federal constitutions, as well as the laws of this nation instituted by and for the people as a sovereign unity of independent states of we the people, not a fraudulent corporate entity of lawyers. This is a tremendous amount of power for a private union that is incorporated and headquartered in Illinois to hold over the citizens of California or any other state. The only recourse is through this initiative process and vote by the people.